Good morning. I understand you're in jury trial.
I am.
All right, so we're gonna,
Second one this year.
oh, it's hard to believe it's 2026, right?
Hey, but I'm 1-0 already, so I'm off to a hot start.
Oh, hey. So how were the holidays for you guys?
Excellent.
Oh, that's good.
Couple days
Me.
off, never hurt anybody.
Oh, yeah. Yes. And Mr. Bonk, it was excellent for me too, as you
Hey,
know.
I saw that. That was
Yeah.
fantastic. Although the candle is still lit.
Yes.
Not time to ring the bell quite yet.
Mm-hmm. All right, the court is calling 2025 CR 006420 State versus Corbin Samansky. Can I have parties announced?
Charles Bunk and Clint Glennie for the defendant.
And are you Mr. Samansky? State, have you received all discovery? Did you review? I'm
Defense.
sorry, defense. Did you? You can tell I'm just getting back, right? Defense, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Samansky, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorneys? Did you understand it?
Yes.
Counsel, do you waive the reading?
We do.
State proceeding on the indictment as presented?
Yes, sir.
Mr. Samansky, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea?
Yes,
in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Samansky, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 7 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. There's no application for community supervision. The state is opposed to your application for deferred adjudication. There's to be restitution, if any, to the complainant. Did you understand that to be the plea? Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states one in attachment.
No objection.
All right. State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court will review the same.
And just like that, the court reviews the evidence and finds enough to support a guilty plea. But notice, deferred adjudication kicks in. It's a delicate balance. Enough evidence to convict, but the court is giving a second chance under supervision. It's the legal equivalent of a tightrope walk. One misstep and the pendulum swings to full sentencing.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So Ms. Ferguson has given me a date of April 13th
Yes, Judge.
for a PSI.
Yes.
What will end up happening is they will interview you, make sure that you make all your dates. There'll be different dates set for each interview. Is there a need for a TAP evaluation?
Yes.
Any mental health evaluation?
Judge, he has.
Any MIC
Yes,
evaluation?
yes.
All right, Vashawn? Okay, it's gonna be a PSI and TAP evaluation and a MIC evaluation on Samansky, and we'll be back on April 13th for sentencing. All right, once you sign the reset form, you are excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Akira said,
Morning, Your Honor.
good morning, how's everything going?
Good.
All right, so I see that she has an MTR and she has a theft
Yes.
case. So are we proceeding on the motion to revoke?
No, Your Honor, we are approaching about the new case, which is the only basis of the MTR.
Mhm.
I have just been given a stack of papers from her regarding her innocence in the new number one
Mhm.
case. I need a little time to get this processed. I would like a reset for maybe 2 weeks to have time to get that together and then, or we can set it for trial, I guess, or contested hearing. I don't know, whatever court wants to do, but there's a lot more to this than what is in the DA's file. I have had discovery from them.
Mhm.
And I'm satisfied they've done everything they have. They brought me everything they have, but I don't think they've been given the whole story, and I've got a whole set of stuff to go through. So I am unavailable next weekend, the end of next week and Monday, the week after that. But I was thinking by the, 30 days to 2 weeks, something like that.
All right, Ms. Ferguson. I need to set for a contested hearing in 30 days.
That's perfect.
I can do the 17th.
Thank you.
All right, so we'll be back. Ms. Abrams, February 17th. All right,
Thank you.
you're welcome.
You're welcome.
All right, Velasquez. Good morning.
Good morning, Judge.
Yes.
Do you have a copy of the latest supplemental report sent in?
Let me see.
If not, I can make a copy real fast.
Oh, all right, thank you.
Okay, Judge. So there was a supplemental report sent into the court in November. There were some concerns in regards to some positive UAs, a admitted use, and some failed BRACs on his device. All of these occurrences happened in July of 2025.
Mhm.
The court was not notified of these until November of 2025. In July of 2025, a TAP was completed. And at the time, the recommendation was for him to do SATIV. He has completed his DWI education, his victim impact panel, and provided his DNA sample. After July, he has not had any positive UAs. That's August, September, October, November, and December. And he has not presented any high BRACs on his device. He does tell me that he is attending AA 2 times a week. And I would ask that the court consider if we can do intensive outpatient treatment and continue his AA meetings. I believe with speaking with him, he understands that he cannot drink. And at that time, I think some things were just happening in his life and he did not know how to possibly handle them. But speaking with him, he's on the right track at this time. So we're asking that intensive outpatient be mandated.
All right, so here's the thing.
Now, this is the human side of the courtroom. Probation isn't just punishment, it's therapy, supervision, and a chance to get back on track. The judge drills into family impact, sobriety, and life choices. This is where the law meets real life. Notice the empathy mixed with authority. And yes, audience, this is why probation hearings can be just as dramatic as trials.
I was informed late that you had this violation. And one of the notes that's on this supplemental report for me is that inpatient treatment would have a significant impact on your family. And I'm sure the impact would be financial because you're an inpatient, you can't provide for your family. These are things that you need to think about when you're thinking about drinking. Because when you're on probation, you're not allowed to drink alcohol, and especially with the offense that you're charged with. I always tell people you need to stay clean and sober for yourself, but if you don't want to do it for yourself, you have to do it for your family. And if you're around people who are drinking or who are encouraging you to do, because I know sometimes that happens when people will tell you, oh, just one more drink, one more this. You need to start thinking about your family if you're not thinking about yourself and your sobriety. Do you understand?
And I have declined several invitations, to family gatherings and stuff like that. Honestly, on Christmas Day, I was by myself. But New Year's Eve, I was with my in-laws, so I was, around, good folk and around surrounded by all that, substance and, like I told her, I've been doing AA meetings, twice, 3 times a week, from 8 to 9, and sometimes just spending time with my family because I don't know what's gonna happen. And I just got a brand new home December 12th, closed on it, and I got that from the family. So I feel like I'm on the right track, doing this thing of life, well now. I'm understanding everything now, just thinking like how I should be, like a 28-year-old man, who just wants to provide for his family. And the little one, we take her to speech therapies twice a week, Tuesdays at 4, Wednesdays 4:30. So it's just kind of tough, just to let that let my wife handle all that just because of my bad decisions and my choices.
Okay. All right. So this is, well, probation, you're asking for intensive outpatient. Do you think, based upon what he's saying and the fact that he's doing sober support meetings, do you think we should just start with outpatient treatment and then if more is needed, do intensive, or you think we should start with intensive?
We can start with supportive, Judge.
Okay. So here's the thing. If supportive outpatient treatment is not working for you, you need to let probation know. Nobody's going to revoke you because you say you need more treatment. Probation is designed for you to realize what your triggers are so you won't come back to court anymore. Okay? Is there anything else you need from the court?
I said, no.
All right. So what I'm going to do is I'll order supportive outpatient treatment and you to do sober support meetings at least once per week.
And here's the takeaway moment. Outpatient treatment, sober support meetings, building a network. The judge isn't just issuing an order, she's giving a blueprint for survival outside the courtroom. Notice the practical advice, calling probation, finding a sponsor. It's strategy disguised as guidance. You see this? This is where accountability meets opportunity, and it's fascinating to watch in real time.
And if you ever think you're going to drink, pick up the phone, call probation. You know what they're going to do? They're going to make sure that you get in touch with somebody who can help you, maybe not take that drink. When you're doing your sober support meetings, talk to people and see who will be a good sponsor for you. Yeah. Sometimes it takes people years to figure out the sponsor that they mesh with very well. So you need to do that. So you'll have a support system where people you can call.
Yes,
all right.
Yes.
Is there anything else?
No, Judge.
All right. Thank you. Thank you for dressing appropriately for court. All right. The court is calling 2025 CR 00.